Welcome, Farewell fans. It is your host, MNG, and I try to bring you the best of the best when it comes to interviews and providing the best information that is out there for your own learning and knowledgeable experience. So today I have James here with me, and he has this book out called Unequal Justice. And before we get into a little bit of that, James, could you just tell us a little bit about yourself?
Absolutely, MNG. Nice to see you. Thank you for having me on. My name is James Porfido. I'm an attorney with 35 years of experience. I practiced in the criminal defense world as well as being a prosecutor for a number of years. I've been an attorney for over 35 years. I'm certified as a criminal trial attorney in New Jersey since 1995 by the Supreme Court of New Jersey. I'm a former prosecutor and head of sex crimes and child abuse and vehicular homicide. I've run a successful defense practice for a number of years. I've represented crime victims. I'm a TV legal analyst. I've talked about a lot of high profile cases over the years on air, a lot of cases that people will know and recognize that were very famous in the news. Cases like O.J. Simpson and Scott Peterson, the Menendez brothers are just a few. I'm also a law professor at Seton Hall University School of Law in Newark, New Jersey. So I'm happy to be on and happy to answer any questions you may have.
Interesting. You said the Menendez brothers?
What was that?
You said the
The Menendez brothers, yes. That was one of the very early cases way back in the 90s. I think it was like 94, 93. And I did some commentary about that case. It was really a fascinating case. And of course, it's in the news again because they're trying to get out of prison. They've been there for a number of years for the execution of the parents. And there were a lot of issues in that case. And they were, they ran the gamut in terms of the appeals that they had or were allowed to pursue, which they certainly did. It's run its gamut through the appellate courts. And now I think they're looking for the court of public opinion to give them a reduction in their sentence or to allow them out. And that's where we are today.
Now, excuse me. Now, I've seen a lot of videos and documentaries on the Menendez brothers, and that was a very interesting. And I know the documentary has nothing to do with the case itself that you probably read about and everything, but that was a very chilling type of event and series to watch. Even for a docu-series or anything, like it was very, very chilling.
Yeah, it was just it's been on Netflix. It's actually very highly rated on Netflix. I think it was in 8 parts. I did watch it. I was fascinated by the case, just the circumstances surrounding the killing and the fact that they had gone out and really were on a spending spree after the death of their parents and made it.
Yeah.
They were obviously making it look like it was some kind of a gangland type or mafia type killing, and there was so much involved in that case. And then ultimately, they raised the defense they were sexually abused by the father and claimed that that was not really permitted in their second trial. The first trial was a hung jury, which means they couldn't come to a verdict. But the second trial, the judge did not permit that type of evidence in regarding the sexual abuse by their father, which they claimed was part of the defense or the motivation or the reason to kill.
Right.
Whether or not that was going to serve as their defense or not, I don't know the answer, but I think that that was certainly explored. And after the case was over and the verdict was returned and they were sentenced, there were a number of appeals through the California courts, and ultimately the verdict was upheld and the sentencing was upheld. So I think they're looking for another bite at the apple at this point in time to try to get, as I said, the court of public opinion, behind them. And it seems like it's working. It was effective with the prior DA in Los Angeles County,
Mm-hmm.
Gascoigne. He actually was considering their release, and he was not reelected. And his successor basically turned it down and said, "No, we're not going to release these guys that were properly sentenced and for the crime they committed, which was so gruesome. Quite frankly, you pointed it out. They
Yeah.
were executed. They were shot many, many times. And the parents were executed. Quite frankly."
Right. Now, you said public opinion. Now, when we talk about court proceedings and jury trials and the news and everything, how much does the public opinion affect the outcome of the trial?
Well, I think it depends, really. You have to look at the particular cases and the situation. You know, a case like OJ, you know, you've got to change a venue. You know, it went from Brentwood, that district in California, to Los Angeles, where ultimately it was tried. And the concern there was that there would not be a racially uh, equal jury, or the proportionality, that he would not
Mhm.
be entitled to a fair jury trial because he couldn't really have a jury of his peers, which we are
Right.
guaranteed. Now, that you know, the case of OJ, you know, there was a lot of publicity surrounding it, and I don't know that he could have been tried anywhere in the United States without having there be publicity. But the feeling was that because of the venue where it happened, that there was so much publicity that he couldn't get a fair trial. So they moved the case to another county. So getting back to your question, it depends on the circumstances. It depends on the case. It depends on how much exposure is out there, how much, you know, the media is covering it. It changes. It varies from case to case. So when I say public opinion, what I mean is, you know, when it's on TV and it's being talked about, or there's a Netflix show that's, you know, getting high ratings and a lot of people are watching it, you know, you're getting that fuel behind the case or behind the story, which
Mhm.
ultimately, you know, leads people to take really strong opinions and maybe even become advocates.
Yeah. And we've seen that happen in with a few shows that came on Netflix where people became advocates, thinking that, hey, there was misevidence, something was wrong. They became like detectives themselves and started digging and started really trying to get into the case themselves to try to determine whether the person was actually guilty or not. And some people started to come after Netflix about that information and saying, hey, the way the video is being portrayed is as if this person is innocent when they're really not.
Mm.
So um, so I can see how that how people could become advocates for something that happened at a different time. You know, you're only getting one piece of the information, and what you're seeing on Netflix is not. It may or may not be the true depiction of what it actually is.
Well, it's challenging because, you know, you can look at some cases and you can see that there were some mistakes made or blunders made, which may be very significant mistakes or blunders made, you know, by the defense, layers of incompetence perhaps, or the judge perhaps not allowing certain evidence in or excluding evidence, you know, properly or improperly. And there have been cases, quite frankly, where people have been wrongfully convicted, and we've seen many of those cases. You know,
Mhm.
Project Innocence. I recently read a book by John Grisham and a guy by the name of Jim Calhoun. It's called Framed. It's a relatively new book. It was recommended to me about people that were wrongfully charged, arrested, uh, convicted by juries, sentenced, and it really is an eye-opening experience to look at that and see those situations. And I read the book like as a defense attorney, former prosecutor, saying, "How did this happen? How was this allowed to happen?" And these cases are not that old. You know, some of them are about 20 years old, and most of them are probably in the 90s. But it's still happening today, where people
Right.
are being denied a fair trial because of perhaps a bias or an interest in the outcome of the case. Like some of those cases had jailhouse informants that were clearly lying. The prosecutor or the state that was going forward on the charges knew that information. They knew these people were not disclosing proper information, or they were not telling the truth, and they made a deal with them to get them to testify. And they promoted that. They allowed that to go on. You know, so those were prosecutorial misconduct cases where clearly the prosecutor was, you know, engaged in misconduct by not revealing this information to the defense. And sometimes the courts were even involved, which is really troubling when
Wow.
the courts were aware that this was going on and they allowed it to go on to convict an innocent person, which is really troubling.
It is. And for me, that's a little disturbing to hear and a little disappointment. Knowing that there is a time that I used to work in the court system. So to know that things like that was occurring and happening, um, whether it's local or it was somewhere else, not local to me, but you would think that, justice should prevail in any situation, and biases should be, left outside the courtroom, because, as is always stated, justice is blind and everybody is innocent until proven guilty.
That's correct. That's exactly it. You hit the nail on the head. That's the fundamental principle that we all believe and accept, is that you're innocent until proven guilty. But I've learned that that's not necessarily so. That the scales of justice are not clearly in balance, and that's why I wrote the book, quite frankly, about my experiences both as a prosecutor and a defense attorney, and saw there was a very different set of circumstances once you became a defense attorney and simply moved from one counsel table in the courtroom to the other counsel table, that the rules kind of changed a little bit. There was a lot of advantages to a prosecution, that you were not given. And, I experienced that. I felt that the courts were predisposed to want to rule in favor of the prosecution over the defense when you made what I would consider meritorious motions. Meritorious meaning that these arguments were made. There were credible arguments. There was evidence to support these arguments, and yet the judges found no, that's not the case, and they denied those applications or motions and allowed the state to proceed. So, I did see a difference, quite frankly, simply by moving, from one table to the other in the courtroom.
Wow. And that's amazing, because I've I've used to talk to some judges in conversation, when I was in a courtroom observing and doing analysis, and from the conversations, some of them give, if the judge was a prosecutor, some of them would give the prosecutors preferential treatment because they were prosecutors, so it's kind of like a camaraderie, a club, whatever you want to call it, right?
Right.
And if they was a defense attorney, they kind of give certain preferential treatment to defense attorneys. There is this club or this alignment that they have with each table, where it's like, okay, well, if I'm over here, I don't rock with the defense attorneys or the appointed attorneys because y'all defending the very people that we're trying to lock up. And if they were defense attorneys and they're on the bench, then it's like, oh well, I rock with them because I'm going to get in the benefit of the doubt. But so we're going to try to push the case forward, regardless of whether the prosecutors have their case together or not. So it was just interesting to hear those conversations. Like, wow, y'all really kind of playing favorites depending on the table based on. And I just recall that based on what you said. I'm like, man, they do really play both sides of the table sometimes.
Yeah, and that's a great point, because how do you separate that out from the courtroom? How do you leave that outside the courtroom? And judges do make decisions, even though ultimately they may go to a jury to make a decision. But the judge can steer the case in a lot of ways by the rulings that are made, by their
Yes.
disposition, by their demeanor, the way they talk in the courtroom, the way they treat the attorneys. Juries can pick up on that stuff. They get it. They can see when the judge is kind of steering them in a certain direction. And that's really the point. Judges are not supposed to be doing that. They're supposed to be unbiased. They're supposed to be neutral. They're supposed to be detached. And you
Yes.
can't show that. You might not like the person in front of you that's accused of a terrible crime. You may hate that person personally on some personal level, but you can't let that be shown. You
Right.
can't let that be reflected. And, because the jury would pick up on that. And I sensed that many times when that happened. Clearly, that if the judge was steering a case in a certain direction, if he didn't like a particular victim, let's say, even if I was prosecuting the case, if he
Yes.
didn't like the victim in the case because of the way they presented themselves or their demeanor, he would kind of subtly tell the jury in a nice kind of way, hey, I'm not seeing this case quite the way, it's coming in. So you have the right to kind of challenge this evidence, or, leading them, steering them towards a verdict that they might, in their heads, might want to have as the outcome.
Mm,
And
that,
I've had that happen. It's difficult because this is what, people have asked me, like, what's the remedy? Like, I bring out the point of unequal justice in the book. I talk about the differences that I experienced on both sides as a prosecutor, defense attorney, and the cases that were high profile that I handled. And they say, well, how would you remedy that? And I say, that's a really great question. I don't know that I have an answer to that. But the fundamental principle of being uh, neutral, unbiased, and detached, every judge should be. They should not have a predisposition. They should avoid conflicts of interest. If there's a conflict of interest, that's their duty and their obligation to say, I can't preside over this case. I fundamentally have a problem with this case because I don't like that person or I don't like that case. And we saw a lot of that happening, quite frankly, recently in the last couple of years, where judges should have recused themselves, stepped away from the case and allowed another judge to preside over it, but they didn't, whether for political reasons or whatever. And that's happening today, quite frankly, with some of the court decisions that are being made regarding the exercise of the president's powers. We're seeing that happen.
Yes.
Whether judges are overstepping their authority. A federal district court judge making a decision to stop or impede the president from pursuing an action, right or wrong. I don't know that is something that is ever anticipated because of our separation of powers. We have a clear distinction in our separation of power, checks and balances, the judiciary, the legislative branch, and the executive branch, and they're all distinct and they operate distinctly. So, we see this happening. It's not uncommon that it happens. And I don't know, it would require, quite frankly, an overhaul of the entire system. But in criminal cases, it's tantamount. It's the number one thing. You have to be in a courtroom where you're getting a fair trial. That's the number one thing. Everyone's got to be treated fairly, and their constitutional rights have got to be protected. And if a
Right.
judge is not inclined to respect someone's constitutional rights because they don't like that individual, or they don't like the charge, or they don't like the outcome, or what ultimately happened, then they probably shouldn't be presiding over that case.
Now, I agree. I agree. There are definitely some judges that they personal lives tend to bleed over into their work lives, and whatever judgments or or ideas that they have about particular individuals, races, or anything, cultures or whatever, they tend to take that with them and put on a robe and then execute that type of justice that they want to execute on a bench because they have the power and the ability to. Yeah.
Absolutely. I don't disagree at all. And some judges have a fundamental bias, whether it's racially motivated or whatever it may be. And they should not be presiding over that case. And they shouldn't be a judge, quite frankly, because if they can't exercise the fundamental principle of being, equal and fair to everyone that appears in their courtroom, then they really should not be a judge.
That is true. That is true. But there's no interview. I don't think there's an interview to be a judge because they are appointed. They are, they run for Congress. I mean, not run for Congress, but they run. They put on their best face, and then once they get the job, then who they are starts to appear.
Yeah, well, it's an interesting point you make because in different states it's treated differently. Some states it's judges and prosecutors, DAs are elected officials. They run a campaign, they run an election, and they get elected to their positions. Like I was
Yeah.
just discussing that California DA that was not reelected. In other states like New Jersey, where I come from, it's appointed through the governor. And I think we're one of the very few states that are very similar to the president. The president can appoint judges. That's how it works. And you have to go through a legislative process in terms of hearings. So each side, based on your political party or affiliations, you get to ask questions of that candidate, whether or not you think that candidate is going to be a good judge. And we saw that just recently when Trump's first term, when Gorsuch and Kavanaugh and Coney Barrett came up as appointments, there was a lot of backlash. There was a lot of back and forth, and we, we haven't seen things like that in the past where people were coming out aggressively talking about them, where they were having hearings where a woman was accusing Justice Kavanaugh of engaging in sexually inappropriate conduct with her when she was like 13 years old and she couldn't recall any specific details. And, that should not have been allowed. It was really, it was trying to really throw shade at this guy in the court of public opinion. And
Right.
it really wasn't a fair thing to do. And it should not have been allowed, quite frankly. And maybe I'm stating something that's a political bias, but I just think for whoever it is, it doesn't matter whether it was Republican or Democrat, no one should be allowed to do that. And what happened to Justice Clarence Thomas many
Right.
years ago? He was subjected to some real terrible things when he was going before the legislative process, and the Senate was questioning him in the committee. So he was subjected to that. He's still on the bench. He's God bless him. I think he's about 88 years old now. And
Wow.
that's another thing. I mean, when did justices of the Supreme Court have to step down? It's a lifetime appointment. So many of them just die in the job. They don't ever step down.
Um, well, okay, so let's talk about that. So I know that at district court level and at circuit court level, there is I think once you get like 70, 72, you can no longer run or, get appointed to be a judge. Now you can come in and be like a visiting judge or stuff like that, but you can no longer hold the bench, hold the bench and be elected again. But you're saying that the Supreme Court, that the highest court in the land, is a lifetime appointment and nobody steps down. It sounds as if, regardless of whether they're sick, senile, deaf, and blind, they get to sit in this position.
Well, that's a good point. Well, I think if somebody is determined to be senile and they're required to get a medical examination, I think they can be removed. Yeah, I think that those cases are exceptional. But yeah, you're right. You're right. I think it's in the federal courts as well as in the Supreme Court. Those are they cannot be forced to retire unless and until an issue like you just made, you suggested, is brought up, like somebody's not competent and capable of hearing a case and able to make decisions of sound mind. Then obviously they can't sit in that position. They need to be removed. In New Jersey, state court judges, the Superior Court judges, through the process at 70, they're required to step down. That's a mandatory retirement age of 70, and they can be brought back on recall. And what you said, they could be basically like a visiting judge. They could preside over cases as a recall judge, but
Yeah.
they're not granted full authorities as a judge would get, sitting on the bench under the age of 70. So it's very different. I mean, in terms of pay structure and things like that, pension issues, all that stuff is all surrounding that age.
So now, just moving on a little bit, when we're talking about these high profile cases, okay, and they're out in the media and they're garnering a lot of attention and everything. How do the media portray of the justice system compared to what actually happens in the courtroom?
Well, the job of the media, quite frankly, the same, is to report, right? To give the facts of the case, not to give opinions. I mean, and unfortunately, we're seeing too much of that, too many opinions and not enough facts. Let people come to their own conclusions. And really, that's really what our system is all about, right? You want to let the jury make the decision based on the evidence that's presented to them, whether someone is not guilty or guilty of the offenses based on what the evidence is that's brought before them.
Right.
And, if the evidence is tainted or the process is somehow tainted with, like maybe evidence should not have been permitted in a courtroom, but it's allowed in, or perhaps there's evidence that should have been excluded that's allowed in, or there's information that was exculpatory. Let's say somebody there's information out there that the individual did not commit the crime and it's not allowed to be presented to a jury. Well, that's pretty damn compelling, quite frankly. A jury should be allowed to hear that information, be able to come to their own conclusion based on the other evidence. I mean, that may not be the only piece of evidence that someone's involved in the commission of the crime. So they should be allowed to hear that, especially if it exculpates them. In other words, it exonerates them that they could not have committed that crime. And there's information out there and they're not permitted to hear that. That's pretty significant.
Now, how often does that happen when there's, pertinent information that is brought up and they don't allow it to be admitted into court? Maybe a video or, something that's very compelling. And they say, you know what, we're not going to admit that into court. We don't feel like that that evidence holds enough to sway the jury.
Sure. I mean, I had personal experience with that. I had a case a few years back. It was pretty gruesome. It involved a grandfather involved in a sexual act with his granddaughter that was about 3 to 4 years of age. And it clearly, in my view, there was not any evidence that this actually happened. And
Okay.
I learned through the course of getting the police reports and doing some due diligence on the case and studying what the evidence would be that would be presented against this grandfather who I represented. I learned that there was a grandson that was present that actually was there the entire time, but they did not interview this individual, this young man. The young man, he was a boy, he's 12 years old. I tried to get the prosecutor to interview this kid because he had information to say, no, this did not happen, because the allegations were so violent and so crazy that I didn't believe. And the interview process of that young girl that was only 3 or 4 years old was so tainted, in my view, from having prosecuted these sex crimes cases. They were suggesting or tainting her words. They were giving her the words to say rather than allowing her to speak. And it was clear to me that it did not happen. And that interview process was tainted. They call it a taint hearing in New Jersey. That the detective was clearly leading her improperly and suggesting what, the anatomical parts of the body, things like that. But to get to the point, I knew that was going to be a later motion to be filed regarding this little girl's testimony, which quite frankly, I don't know how it was ever going to be testified to in a trial setting. But there was this 12-year-old grandson that was present that the prosecutor refused to interview. Well, I went out and embarked upon an investigation, hired a private investigator on behalf of my client, and we interviewed this 12-year-old boy, and he said, no, Grandpa did not do it. He could not. I was in the bathroom when she says this happened. She says she was in the bathroom. I was with him the entire time. He did not do that. He did not do that. Well, I brought this to the attention of the judge, and the judge's determination was that I had not properly interviewed that young man, that 12-year-old boy. He said, I'm not going to permit you to bring this statement to the court because I was trying to fight to get him out of jail. He was in jail waiting for his day in court. He was held on pretrial detention. And the judge did not want to hear it. He said, you didn't follow the proper protocol in terms of how to interview this child. Your interview basically committed a taint, and had done nothing of the sort. This young man was very articulate at 12 years of age. He was able to articulate, no, Grandpa did not do anything wrong. He was in the bathroom. I was there with her, with Grandpa. This never happened. That's it. He was going to be like the lead witness for the defense in the case. The judge said, no, you didn't engage in the proper conduct in interviewing that young man. Therefore, I'm not going to consider what he would have said. So that man remained in jail. He stayed in jail. And it was very, very challenging. That was a very, very challenging. It was during COVID. It was when COVID hit, it was right around that time in March of 2020. And I was the second attorney brought into the case, and I was fighting like you can't believe to get this guy out of jail because I believed so much that he had been wrongfully accused and charged. And I went even to the appellate courts to try to get him released. And the appellate courts denied my request for relief to get him out of jail. Ultimately, I was able to persuade the prosecutor to put him on an ankle monitoring device and release him under house arrest. But
Okay.
that was after he had sat in jail for more than 3 months.
So when I think about something like that, and we talk about appropriate conduct of, interviewing interviewing this 12-year-old boy, but yeah, we have a case scenario where you have the prosecuting attorney, having a 3 to 4 year old, conversation, and them not knowing any better, and as you stated, kind of giving them the responses to say is, it sounds like it's leading.
Well, listen, the detectives are trained. Those are specially trained detectives. When you're interviewing a child witness, you need specialized training because you can't talk to them like you and I are having a conversation. And you got
Right.
to be very careful not to suggest to them the answer you want to hear. You might want to hear
Right.
an answer. You might want to say, hey, grandpa did that to me. Grandpa did this to me.
Right.
Maybe that's in the back of your mind because that's why she's there. So maybe that's the predetermined answer you're waiting to hear. And you might be steering through your questions to get to that result, to those answers. Now, that's not allowed. That's not permitted. And if a judge has a hearing and says, wait a minute, this detective acted improperly in the interview process, then that whole statement is suppressed. It's kept out. It's not allowed in because the interview is tainted. In New Jersey, we have a case, a precedent case that was decided, and it's a reported decision. The Margaret Kelly Michaels decision really laid the groundwork for this type of a hearing. And it's called a Michaels hearing at this point, or a taint hearing, where you say to the judge, I've reviewed this. Look, you get a videotape, and the child is interviewed on the video, and you can look and see what words are being used. Can they identify a body part? If
Yeah.
the detective is suggesting where the body part is and giving it a name, and then that child repeats the name of what the detective suggested, they might say, it's a turtle, it's a frog.
Yep.
I call it my frog. And so the detective then reinforces, says, okay, so when he kept touching your frog, how many times did he touch your frog? You know, that's cementing it in the child's mind. Now the child is saying, okay, I'm getting affirmation. This detective, this person that's interviewing me, they're listening to me, they're hearing me, and they're even using my words.
Yeah. I I just always think that, um when stuff like that happens, and you have anybody in an interrogation, I mean, it could be an illiterate adult, and you're misleading them into stating facts, or or making statements that are misleading, false, and
Mm-hmm.
untrue. And then when you get them on the stand, then the story changes. Nothing sounds coherent or correct. And then you didn't wasted public officials' time. You didn't wasted a lot of people's time with with trying to make a case.
That's a great point because I actually talk about that in my book as starting out as a young prosecutor, and I viewed my role and my responsibility as I'm representing the taxpayers.
Yep.
I'm representing the people of the state of New Jersey, and I would look at a case and I would say, is this case warranted? Is there enough evidence to support the charge? And lastly, does the taxpayer, the public, want me to pursue this case fully? You know, all the way to the trial, all the way through the process. They're paying my salary, so I'm like,
Mhm.
look at, I'm in a fiduciary role or responsibility. I look at it as you've entrusted me to take on this job. I'm going to do everything in my power to respect that. So you're paying my salary, so you're my boss. If
Mhm.
you say, hey, that case is a waste of time, you don't have the evidence, and you're out there pushing this narrative that, hey, this person did something terrible and they were a really bad person, yet there's no evidence to support that, I had a difficult time with that. And I would always take a step back and I'd say, can I, with a clear conscience, prosecute this case and say, yes, the taxpayers would support me wanting to do that.
So let me ask, so knowing all of that and talking about, unfair practices, inappropriate practices and everything, what reforms, if any, do you think will create a more fair system?
Well, first of all, everyone's constitutional rights have got to be protected, regardless, in
Right.
every case situation, as horrible as the crime may be, as terrible as it was as far as the charges are concerned. To answer that question is we do need a level of training. There has to be training. People have got to have a fundamental. There's no real course on like, hey, how do you be a good prosecutor? Like you learn, you go to a class, when you become a
Right.
prosecutor, or you go to a judge's school when you become a judge. But I don't think there's enough enforcement on, you know, maybe a mentoring type of a situation where someone, and you got to be careful with that because if you have a bad mentor, you're going to be a bad student, right? If they're
That's
giving you
true.
bad messages, you're just going to deliver the bad message. You're going to continue the bad message. So, there has to be a process upon which people get that experience. Like, I just, fortunately for me, I just had it within me to look at things like that. I can't say everybody looked at things like that. I always wanted to be fair. I always wanted to treat people fairly. I always felt that they deserved their day in court. But listen, I was a tough prosecutor. When somebody did something terrible, listen, I was going to go after them and I was going to make sure that they got the book thrown at them. I wasn't, and I talk about that in my book. I talk about people that I fought very hard to get convicted and got them sentenced to a very long time, and they deserved it. There's case after case that I talk about where I felt very good doing the job I was doing because I got these people off the street and they had committed a terrible crime and they deserved to be punished. Now, the flip side of that is equally true. If I didn't truly believe that that person committed the crime or the evidence wasn't there to support the charges that were brought against that person, then I had a responsibility to do. My job as a prosecutor, and I always reminded this even when I was a defense attorney to prosecute, your job is not to convict people. It's not to put a notch on your belt. It's to do justice. Do
Right.
justice. Look for what's right and fair. In this particular case, is justice being served? So, it's a very different opinion, quite frankly. And I just was fortunate enough to maybe have that kind of an upbringing where, I brought that into my defense world. I took that same viewpoint and I used it as a defense attorney. And I think it served me well. It certainly served my clients well because I passionately represented them. I really believed in those situations and I treated them like family, no matter who they were, where they came from, what they did. They were like family to me. My clients were like my family. I believed in their case. I wanted to make sure they got their day in court and they were treated fairly.
So let me ask you this. Can you share a case that deeply impacted you?
Oh, I could talk about many, but there's one in particular I speak about in the book, and it really was the reason I left the prosecutor's office in 1997. I was a prosecutor from 1989 to 1997, and there was a particular case, and I'll share a little bit about it because it's a little bit of a story, which ultimately led to me leaving the prosecutor's office. There was a woman that was killed by a drunk driver. She was a mother of three, and the drunk driver was extremely intoxicated. He was more than 2 times the legal limit of intoxication in New Jersey at that time. This is going back to 1994, 1995. The legal limit was a 0.10. Now the legal limit is a 0.08. It actually has gone down a little bit through federal funding. They've required that there be a national mandate across the board that the states all recognize that 0.08 is the legal limit. So getting back to that case, the woman was killed by a drunk driver, and many people had called about this driver and his conduct. He had gone through red lights and he had gone on the shoulder on the median. He was like basically a ticking time bomb waiting to explode. And ultimately, he broadsided this woman who had the green light in her direction and was crossing the intersection, and she was broadsided Her three children were in the car. She was rushed to the hospital, and ultimately she was put on life support. And her husband had to make a very difficult decision to remove the life support. She died. Well, I explained the law that existed in New Jersey at the time, which was death by auto, which is what we call these types of cases. There are homicides with death by autos. When I explained the law that this person had no real criminal history, he could get a maximum of 270 days of county jail as a maximum, or 270 days of community service in the discretion of the sentencing judge if this person
Right.
pled guilty. Well, he was appalled by that. He was an attorney. And he said, Jim, there's got to be something done about the law. This should not be allowed in this day and age. So he said, I'm going to get the laws changed. And I said, you know what? God bless you. More power to you. He went out and he got 100,000 signatures and presented them to the legislatures. And what would have been her 40th birthday, Terry's laws were signed into law in New Jersey, now requiring mandatory sentencing of 3 years state prison if you kill someone while driving drunk. Well, to get back to the case, he was effective in getting the law changed. One person made quite a difference. But we went forward. I prosecuted this individual for aggravated manslaughter, just to give the listeners an idea. It's basically committing a murder without purposeful knowing conduct, having extreme indifference to the value of human life. And through his conduct and his actions, I truly believe there was enough evidence to support that with all the witnesses that had come forward. And he was convicted. He was sentenced to 20 years in state prison for that. And it was the highest level of sentencing in our county, in Morris County. No one had ever been sentenced to 20 years for killing someone while driving drunk. It was kind of a landmark case in our county. And to fast forward to 1997, her husband Bill was jogging near the site where his wife was killed, and he was hit by a car himself. A guy fell asleep, and he was killed. So Bill had started a foundation speaking to high school students about the dangers of drinking and driving, and telling the story about this case and how he effectively changed the laws in New Jersey. So when I found out that he had been killed, I put my resignation into the prosecutor's office, and I took his place on the board, and I spoke to about 75,000 high school students over 2 years, taking his place on the board, on the foundation he had created, about the dangers of drinking and driving. So that was the case that kind of changed everything for me. I decided I don't want to be a prosecutor anymore. I can do a lot more out there if I go out and take on the mission that he took on himself. He started this foundation, and I took his place on the foundation board.
Okay. And just so the people know, where can they get your book at, Unequal Justice?
Well, it's available on Amazon and BarnesandNoble.com. You can certainly find it there. And I have a website devoted to the book, www.unequal-justice.com. And certainly they can find me. I'm easy enough to find. If they just were to do a search for my name, they'll find me. I'm affiliated with the firm in Denville, New Jersey. I still am of counsel, although I've closed my practice and I'm not practicing as a defense attorney any longer. I'm a consultant for the firm, and I'm of counsel to the firm. And we have about 50 attorneys. I'm in the criminal section there. But I'm easy to find. I'm very easy to find. It's not difficult to find me. I'm on YouTube and all over. So.
Well, James, we definitely want to thank you for coming in and having a conversation about your book, just about the justice system, because I'm sure that there are a lot of people that are curious about how the justice system operates, what's going on behind the scenes, and everything. So the information is definitely welcome. I mean, there's some things that I've learned, even though I've worked in the justice system, there's things I've learned myself just from having this conversation. So we definitely appreciate you coming on.
Well, thank you. There's so much to talk about. And, I wish I had a quick, easy solution to the many problems that exist, but I don't. But I certainly hope that there's a vision forward, that people going to court when they're charged with criminal offenses are treated fairly by the courts, and prosecutors look at their evidence and evaluate their cases before they bring a case forward. That's really, that would be my goal is, look, if I can get prosecutors from having been in that position to look at cases and evaluate their evidence. That's always been my goal, even as a defense attorney, and certainly I would want to see that now. And I think everybody deserves that.
I agree. Well, farewell, fans. We'll catch you on the next go around. Once again, thank you, James, for coming on to the show.
Thank
We'll
you
catch
so
y'all.
much, MNG. It was so good to see you. And thank you for having me on.
It's been a pleasure. We'll catch y'all in the next episode.